So I want to say a really big welcome and thank you to Darlene Rites, who is a family law lawyer and accredited mediator. Been doing this work for a long time. And Darlene, you can tell us more about yourself, but RedBird Therapy is super happy to have you here with us.
All right, thank you so much. Thanks for putting this together. I've been to a few of Barbara's other workshops, and they're just fantastic. Some of the other professionals that she's collaborating with. So I really appreciate having this forum to share a bit about myself and mediation. I mean, my goal for today, I'm gonna share my screen actually. Sorry. Can you see the PowerPoint presentation?
Mm-hmm.
Okay.
Yes.
So, my name is Darlene Rites. I'm a lawyer and mediator, and my goal for today is for everyone to fall in love with mediation. And so if you don't feel that way at the end, I want you to send me an email so that I can continue to have this discussion with you, because I'm obviously biased, but I do think that mediation is the best way all around to resolve disputes stemming from a separation or divorce. So I'll just talk very briefly about myself, but I'll do this again at the end. So I'm a lawyer and mediator, and what that means is, I work with clients in my capacity as a lawyer, which means that I represent one party going through a separation or divorce, and I also work with couples together as a mediator, where I try to assist them reach a negotiated settlement on all the issues stemming from their separation. So just a bit about that. Today, like I said, I do have a goal, and it's to help you guys fall in love with mediation. But just a bit about what I'm going to talk about. So a brief introduction, which we've just done. I'm going to talk a bit about family law, because a lot of time, often, clients will come in and they're going through a separation, and they actually don't know what family law is. They don't know what a family lawyer does. They don't know, I guess, what topics are covered by family law. So this will help, especially a lot of you, it seems like a lot of people attending are social workers and working in that space, just to identify, when it's important for a client to meet with a lawyer, or when mediation might be appropriate, and just to identify those issues. I'll talk briefly about alternative dispute resolution. So mediation is one form of alternative dispute resolution, and basically a way other than court and litigation to resolve a family law matter. I'll go further depth into what mediation is and describe that process. And then the propaganda will begin, the benefits of mediation and why it's so much better than litigation for resolving a family law matter. And then I'll go through some brief case studies, and I have planned for a formal question and answer, but I do hope that this will be interactive. So I encourage you to either write your questions in the chat, or if you don't feel comfortable writing them in the chat, you're welcome to email me. I will try and monitor my email during the presentation. So either way, and if I'm not seeing the messages in the chat, feel free to unmute yourself and interrupt me if you feel comfortable, and I'll try and answer things as they go. Just a quick disclaimer, everything I say is factually correct, and it's accurate, but it's only legal information, not legal advice. And what that means, is, you shouldn't rely on this information, because I don't have the entire picture. So if you are going through a separation, or someone that's going through a separation, it might seem like this information will apply to them. But everything I say, usually there's an exception, right? And so what I say might apply to 95% of folks, but if you happen to be, your friend happens to be in that 5%, if they're relying on this, it's really doing them a disservice. So just keep that in mind during the presentation. All right, so if there are no other questions, I'm just gonna get started. I'm going to start with the family law basics, and just talking about, the 4 or 5 main categories that that we deal with in family law. So whether you're in court, whether you're dealing with things through lawyers, in mediation. So the first big ticket item are parenting issues. So in this, you know, we talk about decision making. So about 2 years, the language in the legislation was changed from custody to decision making. Basically, the motivation for that was that, you know, custody, it was such a loaded term, and it was this, you know, if you had custody, you won, and if you didn't, you lost. And so they're really trying to change the language and the discussions around that. So now we talk about it as decision making, right? So who's going to be making those major decisions for the children? And one thing I always try to convey to clients is, you know, most people already agree on those major decisions, right? So people, at least in my practice or my experience, spend a lot of time, energy, and money fighting over, you know, things like decision making, when in reality, that's not what's going to impact your life. That's not what's going to impact your relationship with your kids. And so, you know, when we're talking about decision making, we're talking about those topics like, you know, where are the children going to go to school, like which school, you know, if there are any medical decisions that need to be made. And again, you know, 95% of parents, you know, especially if they're not doctors, you know, if the doctor says your child needs an operation, most parents will agree with that course of action and that recommendation. The other thing in this category is parenting time. So physically, like, where are the children going to be residing, right? They're going to be living with each parent on a you know, week on, week off schedule, or are you going to be changing every few days? In that, you know, we talk about the holiday schedule or mobility. If one parent wants to leave the jurisdiction with the kids, what will that look like? The other talk we talk about in family law is property division. Okay, so basically, with, you know, there's a difference whether you're married or common law. Okay, so common law spouses, regardless of how long they've lived together, don't automatically share in the same property rights as married spouses do, and that's a huge misconception. A lot of people believe that after, you know, 1 year, after 3 years, they automatically get the same property rights as married spouses, and that is not true. There are exceptions to that, but it's the exception and not the rule. And with married spouses, you know, a very simple explanation of our family law is any wealth that was accumulated during the marriage gets split, gets equalized. Okay, there's obviously a lot of exceptions. You know, one of them, you know, if you receive an inheritance, that can be excluded in certain circumstances, things like that. But that's generally how it works with married spouses. And the fact that, you know, one spouse didn't contribute financially doesn't really matter in our property regime. Next thing is child support. So again, basically, you know, if the children are living primarily with, you know, with one parent, the other parent has an obligation to pay monthly child support for that child. If the children are living at least 40% of the time with each parent, then each parent pays child support to the other. And what that actually looks like is, you know, a setup of child support, right? So if parent one has an obligation to pay $1,000 a month because of their income to the other parent, and then parent two has an obligation to pay, you know, $500 a month, you know, that higher income parent will just pay that set off. Okay, so that's very simple, in a simple way, how child support works. That monthly payment is intended to cover things like food, rent, or clothing. Things above and beyond that. So we're looking at Section 7, special and extraordinary expenses. So it might be extracurricular activities, so hockey or ballet or music. It could be medical benefits that aren't covered by your insurance. So like the orthodontic expenses. And the biggest ticket item is post-secondary school expenses. And those things are typically shared in proportion to income. So if you and your spouse earn the same amount of money, those expenses will be shared 50-50. If one person, you know, earns 70,000, the other person owns 30,000, that's how it will be apportioned. Okay. Another big topic we deal with in family law is spousal support. So kind of two stages to that analysis. So the first is determining, if someone is entitled to spousal support. And the second, if it's found that they're entitled, determining how much. And so just a very brief, comment on spousal support. So there are a lot of factors that determine whether someone is entitled to spousal support. So, the longer the marriage, the higher the likelihood that, or a relationship, common law spouses, same spousal support rules apply to them as well, even though it's governed by different legislation. So long-term relationships, if there are kids, if there's a disparity in incomes, if there's a compensatory basis for support. So a good example of that is, long-term relationship where one person has stayed home to care for the children, and they really need to be compensated for that because they're out of the workforce and they've really passed on opportunities to advance their career. Or another example of that may be, sacrifices that one person made to help advance the career. We often see this with professionals where, they take turns, right? One person's working so that, the other person can go through their studies and get licensed, be it as a doctor or a lawyer. And so, the law recognizes those sacrifices and will usually award spousal support to that supporting spouse. The last is divorce, and really that's a piece of paper that you get, and people want that. A lot of people choose to just stay separated and never officially get divorced. And I always say there's about 2 to 3 reasons why you would want a divorce. So sometimes it's just emotionally, people don't want to continue to be tied to their former spouse. So they want that piece of paper, they want that closure, and they want to be able to move on. Second reason is if you plan to remarry, you need a divorce in order to be able to remarry. The third reason is when people have property in other jurisdictions, you oftentimes need the divorce to deal with that. So I'm obviously only licensed to practice law in Ontario. But my background is Portuguese, and I have a lot of Portuguese speaking clients, and I'll often work with lawyers in Portugal. So I know if there is property there, then the divorce needs to be registered to be able to deal with that. Otherwise, the spouse will continue to have rights with respect to that property. So I always recommend when we're dealing with other jurisdictions that clients speak to lawyers in that jurisdiction. And here are just some other issues that we might deal with that you may not think of is a family law issue. So I have a lot of partnerships with various shelters. So I deal with a lot of domestic violence victims. So obtaining restraining orders from court may be something that we deal with in family law. Grandparent contact or other extended family contact if they're not being permitted to see the children, that might be something we deal with. International child abduction and Hague-related cases, or domestic contracts, and that can be a marriage contract, or it's more commonly known as like a prenup in the States, or separation agreements. So, any questions before I move on?
There's one here in the chat from. It says, is child support mandatory? And if both parents agree that they don't want or need to have support payments to each other, can they opt out of support payments, both for child support and spousal support?
So yes and no. So child support is the right of the child. So given that it's the right of the child, you technically don't have a right to waive that. Practically speaking, people do that all the time. And basically, especially when there's a shared parenting arrangement, which is where each parent sees a child, at least 40% of the time, it really allows you to be more flexible with respect to child support. So there's a section in the legislation that actually, instead of doing the set off that I explained, which is a much simpler way of coming up with it, they'll actually have you look at, the budgets and the needs of each household to make sure that the children are being cared for. And so determining, what money needs to exchange hands that way and looking at the expenses. The other thing with respect to a divorce, a court a judge won't actually grant you a divorce unless you've dealt with the issue of child support. So you actually need a separation agreement or something dealing with child support. And in cases where parties have decided that no child support will be payable, you just have to explain to the court why that's in the children's best interest. Okay, so it's just kind of an extra step that you will need to show because it is a requirement. Does that answer your question? A long-winded answer, that, but
it's the law. It's complicated. I have another message here, a question. How long is a spouse entitled to spousal support when they've been in a lengthy marriage, for example, 21 years or more?
Okay. So I will limit the times I use. It depends in answering questions, because I know people hate that. It does depend. But with long-term marriages, typically, so lawyers and judges, we rely on they're called the spousal support advisory guidelines, and it will actually there's a formula, like, I mean, that you know, you can read about it and how it's applied. But with long-term marriages, it will give you, sorry, when you're asking spousal support for any time, it will tell you a length of time, like usually a range. And with long-term marriages, the range is indefinite. And that doesn't mean forever. It just means that there's no end date. And you know, and in order to change it, you would have to show that there's been some material change in circumstance. For most people, that would be retirement. So the payors, I guess, income at retirement usually changes. For most people, it's reduced, so it would warrant a change or revisiting, you know, what's being paid. Sometimes that material change in circumstance could be the recipient. So perhaps they've been outside the workforce for a long time, and you know, and they're slowly getting back in. So when they're finally working, or when there's been, you know, a change in their income, then it could be another reason to revisit that. Okay. Right. Any other questions before I move on? I'm having problems. Oh, I see the chat now. Sorry. Okay. All right.
Just to let you know, if somebody wants to send me or Darlene a direct message, if you don't want your name to show in the chat box, that's totally fine.
Okay, so I'm going to talk about other alternative dispute resolution, I guess, avenues, and recently there were changes to the legislation that deals with family law. So it actually requires parties to try to resolve their dispute using alternative dispute resolution. So this was, you know, a big deal, at least on paper, requiring parties to try other methods before they resort to court. You know, I haven't seen the research on it and whether, you know, it's increased the use of these methods, but you know, I thought the legislation at least was quite promising. So the first is negotiation. So, you know, I've written here lawyer to lawyer negotiation. That can happen between the spouses. In a lot of cultures, it actually happens with the entire family, and the extended family and the parents are quite involved in those negotiations. And so really all that means is you're trying to reach, you know, a settlement with the other party. Mediation, which I will talk further about later in my presentation. But basically that's it's a voluntary process, and it uses the assistance of a neutral third party that is really just trying to help the spouses reach a negotiated settlement. And that can happen with the spouses alone, or it can happen with the spouses and their lawyers. So, arbitration. This is it's a private process where you're you know, hiring a third party to resolve the conflict, and it's binding. So it's basically, it's similar to court, except you're paying for your judge. And you know, the benefit of that is you get to choose the judge, so both parties get to select who the arbitrator is. It's usually a bit quicker. And but the one thing with arbitration, and you tend to see it being used with more affluent couples. One, because you're paying for an expense that if you were in court would be free of charge, right? You don't pay the judge directly for their time.
Good morning, I'm line, Hannah speaking.
Good morning, welcome. Then there's mediation arbitration. So it's basically joining mediation and arbitration. So you start the process with mediation, so where both spouses are trying to reach a negotiated settlement. But if negotiations fail, then that same mediator will then put on their arbitrator hat and make a binding decision. Okay, so people like this process because of kind of the finality. They know that at the end of this mediation arbitration, there will be a final binding decision. And the last is collaborative law. So this is where parties work with their lawyers to try and resolve the issue. And collaborative law, the lawyers need special training. And basically, the spouses agree that they will not go to court. And if they choose to go to court, they have to get new lawyers. So there's, and whenever you change lawyers, there's a cost with that, right? Because the new lawyer has to kind of get up to speed on your file. And so there's a real incentive to try and settle outside of court. So any questions about these various methods of alternative dispute resolution? So that I'm seeing a message about an earlier slide. Can you briefly discuss more about grandparent contact? So recently, again, I'm talking about all these recent changes. So they happened about 2 or 3 years ago during COVID, and they were implemented a bit later. But basically, where grandparents now, they could always bring a court application, but now it's specifically set out in the legislation. And grandparents can bring an application, just like any parent would, to have contact with their grandkids. And so they would have a court order, just like a parent would, allowing them to see the kids on certain days or however often per month. That's something that can also be mediated, right? And we can use any of these alternative dispute resolution mechanisms to deal with those issues. But that's what I was referring to when I mentioned grandparent contact. All right, so mediation I've already talked about what it is. I want to discuss the process, just so you kind of understand how it takes place. So we start with an intake or screening. So I would meet with each party separately, and here I'd learn a bit about them, what they're really looking to get out of the process. But probably the most important part of that screening and intake is the screening for power imbalances. So my goal as a mediator is to structure a mediation and structure a process that's safe and effective for the parties, right? So if there's if there are power imbalances, so this could mean like a history of domestic violence, right, where one person just doesn't feel comfortable standing up for themselves or won't be able to advocate effectively for themselves. It doesn't mean that mediation is not appropriate, just means I have to structure in a way that will be effective for that couple. And that might mean not having them in the same room and doing shuttle mediation. So I'll often do that, whether it's in person or Zoom. Each of the spouses will be in a separate room, and I will go back and forth between them and mediate the issues, right? So and that equals the playing field, because no one's expected to to speak up or advocate in front of their spouse, which can be daunting for some folks. And also, if one person wants to bring their lawyer to the mediation and the other person doesn't, I wouldn't structure mediation in a room where one person's sitting there with their lawyer and the other person's self-rep. So again, in those situations, I would separate the parties. Then the first mediation session takes place, and that's where we explore all the different issues. Usually the parties have to agree on what issues they're going to mediate. So sometimes they might say, okay, we're only coming to mediation to deal with the parenting issues, and we're going to deal with the financial issues elsewhere, or they can agree that they want to deal with all the issues. And at that first mediation session, my goal is really to identify barriers to settlement. So that might be the positions of the parties, but it might be more practical barriers. So if there's a house or matrimonial home that needs to be sold, right, we identify what needs to be done to get that listed, right? So are the parties agreeing on a real estate agent? Or do any repairs need to be done to the home? And we kind of make a plan so that with a goal of getting the house sold and a timeline that everyone agrees to. Or another barrier to settlement, what, you know, one person may have a business and that business might have to be appraised, right? We need a value. So we agree at that first mediation, or we discuss whether the parties are going to be jointly retaining an expert to assess the value of that company, or the same with assessing someone's income. So we make a plan, and you know, over the next few weeks or however long, you know, we execute that plan. The next stages is really, you know, information gathering, and then having additional mediation sessions to kind of execute the plans we put in place during that first mediation. So when I mediate for couples, I help them prepare their financial statements. And so I'll provide them with a list of everything they need to gather. We'll exchange financial information so that everyone has all the information that they need to make an informed decision. During this process, if they need to consult with third parties, right? So the family law is one of those unique areas of law that touches so many other areas. So sometimes they need to meet with tax professionals. I mean, I'm able to identify the issues for them, but then there's certain things they need to talk to an accountant for, or a tax professional, or you know, a business lawyer. If there's a business involved. So I make sure that everyone is well informed, that they get the advice that they need, so that when they're in a mediation session with me, they're fully informed, and they know what their, I guess, parameters are in terms of negotiating and settling. So if an agreement is reached at mediation, next step is I prepare a separation agreement, and I, you know, and I do this throughout the process, but at that point, at minimum, I'll encourage the parties to obtain independent legal advice. Because as I mentioned in the beginning, you know, during the in my capacity as a mediator, when I'm working with both spouses, I can't give them independent legal advice. It would be a conflict of interest. Because I'm a lawyer, I'm able to provide them with a lot of legal information. So none of my clients will ever go to a lawyer and be shocked by anything they hear, because they've been getting that information during the process. And that's just one of, you know, so in family mediation, you don't have to be a lawyer to be an accredited family mediator. You don't even have to be accredited. So that, you know, and those are just some things to look out for. There are some fantastic family mediators that have a social work background, and they focus on a lot of the parenting issues. Some will do all the issues, and just something to keep in mind when you're working with a non-lawyer is to make sure that that the parties are going for independent legal advice and meeting with a lawyer early in the process. And one, because they need to know their rights, but two, like when you wait too long and they're unaware of certain rights or obligations, it destroys the goodwill that's been built in the mediation process. So if I had two people that agreed on things, and then I sent them off to go lawyers, and they're learning for the first time that, oh wow, I actually had a right to spousal support, like no one told me this. And then they come back and they want to deal with the issue of spousal support. Well, to the other party, now it seems like they've broken that promise, right? And it's legally, they're allowed to go back on it until they sign the separation agreement. But had they known that at the beginning, then we could have had, a different discussion. So that's one of the challenges and one of the benefits of working with an accredited mediator who's a family law lawyer and is providing individuals with that information. And okay, so you're on separation, legal advice. Okay, and then implementation. So the agreement is signed. You know, at that point, the parties can choose to go off on their own. I always offer to kind of, you know, close things off for clients and just make it kind of like a one-stop shop, and where, you know, there's no loose ends, right? So for example, if there's child support or spousal support in the agreement, either party can choose to file the agreement with court. And what that means is then if there's an issue with payment, there's an organization in Ontario called the Family Responsibility Office that will actually take you know, take the lead and enforce support. And they have a lot of authority, right? So they can garnish wages, take away people's driver's license, you know, eventually put people in jail. So that might be something that the parties need assistance with, just registering the court so that that organization, you know, also, it's also nice for accounting. The organization just tracks what's been paid, what hasn't, right? So the payer pays the organization, then that FRO organization then delivers payment to the recipient. If there are pension transfers, so sometimes in the property settlement, parties will agree that, you know, that payment will be kind of a direct transfer from their pension to the other, or an RRSP. So I can assist with that paperwork, and then also divorce. So I can help with that as well. I'm just gonna look at the chat. It seems like there's a few questions. If a spouse has been out of work for a long time, say 10 years, because they have been a stay-at-home parent, what can they do to secure a job, if anything? I'm in Toronto, would also need childcare. So there are a lot of resources that might help a parent, you know, get with retraining and getting back on their feet. But it really depends, I guess, what field you're in, and you know, again, if the separation was fairly recent, you know, you may be entitled to spousal support, and that might, you know, provide some financial assistance until you're able to get back on your feet. Could a mediator help a married couple rewrite a marriage agreement without the outcomes of separation and divorce? So a marriage contract can be prepared at any time. So it can be done before the marriage or after the marriage, and you can also amend it. So yes. One thing I usually tell people is, so in a marriage contract can basically say that you don't want the regular law to apply to you. And people usually do this when they're bringing assets into a marriage, right? So you can say, okay, even though we're married, what's yours is yours and what's mine is mine, and we're not going to have the law apply. A challenge with having it prepared after the marriage is that, you know, the party who stands, I guess, to lose might not have a huge incentive to sign it, but it's perfectly legal, and I have done them. All right. If a common law partner raises their partner's child from 4 for 20 years and they are disabled, if there's a separation, could there be spousal support? 100%. So common law parents who are living in a common law relationship. So parents generally, all parents, no matter what their living arrangement, even if they've never resided with the other spouse, have an obligation to pay child support. So like I said before, child support is the right of the child. I'm not sure if you mean that the parent raising is a step parent, so not the biological parent of the child. And yes, step parents may have an obligation to support children. And so, you know, the test is whether they stood in the place of a parent. So this usually means if they treated the child as their own, if to the public it looked as if they were their own child, if they're, you know, supported that child during the relationship, then they may have an obligation. It's not as straightforward as a situation where, you know, biological parents are separating. And the court will look at things like, you know, is the biological parent paying child support and supporting the child and things like that. But yes. If a spouse is mentally ill, not working, and not cooperative, what typically happens? It depends on the issue. You know, with mental health issues, depending on the capacity of the spouse, mediation may or may not be appropriate. If someone is not being cooperative, then you may need to start a court application. And, you know, sometimes and with court applications, I mean, there's timelines and things you need to do. So there's consequences for a lack of cooperation, right? So after a certain amount of time, you have to, you know, prepare your pleadings, produce certain disclosure. And if you don't, then the other spouse there are things that they can do to get things moving forward, right? So you can, you know, strike their pleadings, you can proceed on an uncontested basis, you might be able to get an order that they pay you a penalty for all the time and expense you're spending. So it really depends on, you know, what uncooperative means in this case. I'm going to just continue now, and then I will get back to some of the other questions in the chat. Benefits of mediation. So these are just some of the benefits of mediation. I'm going to go through each of them separately. Some quicker than others, but feel free to continue asking questions. So cost saving. So, you know, mediation, I'd say 100% is a much more affordable option than going to court. With court, there's mandatory steps that you must participate in. And if you have a lawyer, there are things that the lawyer must do, paperwork that the lawyer must prepare, that just takes time. And so court is just designed, the way it's designed is just more expensive. You know, preparing court pleadings is expensive. And, you know, a motion. So in court, there are steps. So, you know, you start the court application, there's a case conference, and then there's a settlement conference, and then there's a trial management conference. And if the matter is not resolved, eventually there's a trial. If between those processes, there's anything urgent that you have to deal with, and usually the common ones are, you know, someone needing child support or spousal support, or someone wanting to sell the house and the other person isn't cooperating, you need to bring a motion. And motions, just like one day asking the court for usually one thing, expect to pay legal fees between $5,000 and $20,000. And so that is, I think that's crazy. And I'm sure other people do as well, you know, but, you know, and obviously, you know, on the lower end, straightforward motion and $5,000 is not insignificant, but you're looking at the lower end. And when you're looking at a motion that will cost 20, I've seen, you know, $30,000 spent on a motion. Most likely it's relating to a parenting motion. So, you know, I did a parenting motion last year where the other spouse had some mental health challenges. So in preparing my motion, there are a lot of text messages, there are police reports I had to go through, there are medical files that I had to go through in preparing my client's material, and just looking at all that disclosure. I mean, that took a lot of time, right? And so the client was successful, but, you know, at what cost, right? And so mediation, you know, is just a much more efficient use of resources. And also one thing that people forget is mediation can be used to narrow the issues, right? So if you go to mediation and you resolve one, you know, and I mentioned those issues at the beginning, right? So there's the parenting, the property division, the support. And so if you can narrow even one of those issues, that means that court will be cheaper, right? Instead of a 4-day trial, maybe your trial now is 2 days. And with those steps in the court process that I mentioned, right, like a case conference, like you sometimes wait months to see a lawyer, to see a judge, and you have maybe 10, 15 minutes with that judge after waiting months and months. So a judge will not be able to deal with all those issues. So if you've gotten some off the table, then the judge can spend that time actually helping you with the issues that are contested. So time efficient. So litigation is just slow. I mean, depending on what court. Toronto is fairly decent, right? So if I were to start a court application now, the first time you'd be in, unless there's something urgent, but the first time you'd be in front of a court is probably February or March. So that's what I mean by decent. There are other jurisdictions, so Brampton or Newmarket, you might be waiting 6 months to a year to get your first date in front of a court. That to me is also crazy, because imagine separating from your spouse and there being conflict and not being able to get in front of a judge to help you resolve some of that conflict for a whole year. That means, a whole year you're dealing with, possibly parenting issues or scheduling issues or not getting support or, so I think, and so mediation a lot quicker. The scheduling really depends on the availability of the parties and the availability of the mediator, right? Sometimes we have to wait because we're waiting for reports or pension valuations, but other things can be resolved in the meantime. I'm just going to check back at some questions. One threat that is common with an abusive partner is that they will use their spouse's mental health to ensure they don't get access to their children. What does someone have to do to prove someone is unfit to parent? So I mean, 90% of my clients think that their spouse is a narcissist. And that their spouse has mental health issues. So those allegations are used a lot in family law, especially in the litigation context, because litigation really forces you to look back instead of looking forward. And so really, the ultimate test when deciding anything relating to parenting is what is best for the kids. So if they don't actually have evidence that a spouse's actions or even mental illness is negatively impacting the children, then that spouse is still going to be able to see the children and co-parent with that other spouse, right? In extreme cases where you've been able to show that there are some, challenges and that the children might be at risk, there's something you can get like a parenting assessment. Again, it's very costly, where a parenting capacity assessment. And I'd say those are really rare, where basically, you have a neutral third party, doing an assessment. In court, oftentimes, there's something called the Office of the Children's Lawyer, and we can get a court order that the Office of the Children's Lawyer be appointed. There's two ways that the office, so it's a publicly funded program, so they don't accept all cases. So usually reserved for the high conflict or where there is mental health issues. So they can work with the parties in two capacities. The first is a social worker is typically assigned. They meet with the parties, anyone really that deals with the kids. So it could be, new partners, teachers. They will read all reports, if there's any medical reports, if there are any police reports, if there's any files from the Children's Aid Society, and they will produce a written report with their recommendations on decision-making and parenting time. And then the other way that the OCL can become involved is through a lawyer is appointed, and the lawyer actually represents the child. So you have kind of spouse one, parent one's lawyer, parent two's lawyer, and then a lawyer for the children. The other thing, if there are accusations of a parent's, ability to care for the children, we sometimes see supervised parenting time. And, I'd say it's a bit controversial. I mean, sometimes parents, some lawyers will tell you, never agree to supervised parenting time. It'll, I am not of that. I don't think it's as terrible as, or necessarily prejudices you, because it moves things along quicker, right? So you can fight the no parenting time. And obviously, if it's completely inappropriate, then not. But in cases where, there's a hint of truth to what's being said, it sometimes helps resolve that dispute, because, if there are allegations that, parent is acting inappropriate with the children, saying inappropriate things, or doesn't know how to deal with things, especially with like young babies, right? Where we've had a primary caregiver and the other person really has not even changed the diaper. When you do supervised parenting time, again, you have a neutral third party that is supervising that time. And if it's a professional organization, they're actually taking notes. So then we have this evidence to show, well, no, this person is actually perfectly capable of caring for the children, and there are no issues. And then you're in a much better position. You're in a much better position to go to court to ask for unsupervised time than you were before, where it was, well, you know, he said, she said, or parent one said, parent two said, because really sometimes a judge doesn't know who to believe, right? When a judge is making these decisions, they're usually making them based on affidavit evidence. So they don't get to hear from the parents. They don't get to assess credibility. And judges, you know, rightly so, probably want to err on the side of caution. So if there are these crazy allegations, you know, so my goal is to kind of find the evidence and find the support so that judges can make an informed decision that's best for the kids. Okay. Grandmother's son dies. His wife refuses access to grandson, so she could have put a court order for access. Correct. Okay. I'm going to move on. So flexibility. So again, litigation is a blunt tool. There's real limits on a court's ability to deal with certain issues. And I'm just going to highlight a few here. So pets, for example. So in Ontario, I'm sure we have pet lovers in this room, but in Ontario, pets are considered property. So, it kills me when I have to deal with things in court. And it's really, if you have a receipt for this pet, it's yours. In mediation, obviously, we can take a much more human approach. And I've developed, parenting schedules for pets post-separation. Communication breakdowns. A court is not designed to help with communication breakdowns, right? They can, the orders that they can make are just very high level, right? They can order that, you not speak negatively about the other spouse, but they don't actually provide you with the tools that you need to communicate with the other spouse. And a good mediator can help you with that. The same with detailed parenting plans. Right? Like courts are not designed to, courts aren't designed to come up with detailed parent, like there's just no time for it, right? And even at a trial, I mean, the judge just doesn't have the capacity to put the level of detail that a parenting plan really deserves. In terms of mediation, it can be used for temporary agreements. Well, I often use it for, so there's this misconception that when you leave the matrimonial home, you lose rights to the home, and that's not true. You can leave at any time. You don't lose any rights. The only time I suggest that people not leave is when there are young children. Because what happens is if one person leaves the home, the person who stays in the home with the children can decide to unilaterally dictate the terms of parenting time. And so although each parent has a right to spend the same amount of time with their children, the parent who resides with the children can really dictate and just refuse to facilitate parenting time. And so if you're waiting for a court, it might be 6 months before you're able to see your children. So in those situations, unless there's safety concerns, I recommend that people stay in the same home. But sometimes, people just need to get out, and there's a lot of conflict in that home. So we'll mediate, we'll do a kind of an urgent mediation just to come up with a bare bones parenting schedule to tide them over until we can sit down and deal with the parenting issues. So it prevents one parent from kind of, just completely blocking the other parent. Another thing I want to express is that mediation can be used at any stage of the process. So it can be used as kind of your first stop after a separation, before a court application is started. You can do mediation after a court's application has been started, even after you've attended court. You can do it kind of, just before trial, like at any time, right? And again, like I mentioned before, even if you just agree on a few issues, it will make the rest of the process a lot smoother. Confidential. So, court is a public forum. Any person can go in and see documents filed in a court case, and mediation is confidential. And it just, because it's, usually mediation, it's a without prejudice process. So you're sitting in the room, and it really allows you to be vulnerable. It allows you to put your best foot forward and make settlement proposals that you probably wouldn't otherwise make. Because if you're in the court or litigation mindset, you're really thinking strategically, and you're thinking, well, I don't want them to know that I'm okay with this position because, I'm, saving that to bargain on something else. And with mediation, like nothing that is said in the mediation can be used in court. So it really allows for, for everyone in the room to kind of think creatively and really try to get things resolved. Preserving relationships. So this is probably like my favorite, and particularly where there are kids. Litigation, I mentioned before, it focuses on the past. And so when you read pleadings, it invites you to write the worst things about, your spouse that you can think of. And it's adversarial, right? It's that win-lose mentality. And with mediation, it really reduces conflict and helps maintain and rebuild those relationships. And I see this, one thing I mediate is marriage contracts, and I can't think of a better time where someone would want to preserve relationships, obviously when you're starting a relationship. And I've had relationships break down because two lawyers, when they're none of my clients, but I've seen colleagues, like when two lawyers are negotiating the terms of a marriage contract, it didn't sit well with the spouse, and it's actually destroyed the relationship before it even started. Whereas when we're mediating those, you can kind of soften, some of those issues and have the discussion in just a more holistic way. One example I can think of, last year I helped two close family members. I wasn't representing them on their separation, but I was kind of, they were sending me all the correspondence between the lawyers and providing them with some advice in the background. And I really got a glimpse at the client's perspective when dealing with lawyers, because they would get a letter from, the other spouse's lawyer, and they would just break down, and they would do like, do you believe the tone of this letter, right? And I'm reading the letter and I'm like, what tone? And it's letters that, I might send. So just the way, even like lawyers' correspondence, right? Like depending on the style of the lawyer, just the way it's perceived can destroy opportunities to settle, right? So if a lawyer writes something in an aggressive tone, right, they're seeing it as coming from their spouse, right? They're thinking, my spouse told the lawyer to write it in this way, and they see it as a personal attack, and that really destroys opportunities for settlement. And with mediation, I can control that, right? If the parties aren't being civil to each other in the room, again, I can separate, I can kind of filter that communication to help us move towards a settlement. I'm just going to go back to the chat here. For child support in this scenario, child support had been agreed upon till kids are 25 and 22, which equates to 4 years post-secondary. Can the parent receiving child support ask for more after that? On what basis can they do that? Can they say it's because the child is not independent yet? So yes and no. I mean, if there's been an agreement and you guys have agreed to an end date, then that, the parent paying can rely on that end date. But since child support is the right of the child, there's usually some flexibility. And if the parties can't agree to that on their own, it would usually require going back to court. And I'd say in most cases, that's probably cost prohibitive, unless we're dealing with a child that for reason of like health issues, mental health or disability, can't become self-sufficient. And so perhaps that was not known at the time, so something like that. But, if they're already paying until the child is 22 or 25, there needs to be pretty compelling reasons why child support would be payable after that. Generally, the rule is child support will end at 18 unless they're in full-time studies. And for most families, it would mean, supporting until the first post-secondary degree, even supporting through things like professional colleges, like medical, dental, legal. unless the parents are quite affluent, or unless there was an expectation during the marriage that they would support the kids through these professional schools, it's very rare for a court to order that, you know, a parent support their children through those programs. Is it reasonable to expect that a child that has an undergrad degree cannot be independent? It is reasonable, but whether they're entitled to child support is a different question. And usually after that first post-secondary degree, I'd say that child support would end. And it's tough because parents, usually like the primary parents, especially if the parent is residing with one parent, continues to have that burden. But unless there are reasons like you know, health and disability, I'd say mostly you would not be successful in having child support after that. Okay, compliance and follow through. So, you know, there's a lot of studies that show that if someone reaches an agreement on their own, as opposed to it being imposed on them, they're more likely to comply with it and follow through. And this is an interesting one. And the first time I heard of this, I was practicing family law probably just a year or two, so I was quite junior. And I was in court, and sometimes judges will ask to see the parties separately. So they'll send one party outside, and then they'll have a frank discussion. They'll say things that they wouldn't say in front of the other party. And I was representing, I remember the mother in this case, and the children were with her, and I can't recall now if it was child support or spousal support. And basically, dad had made a proposal, and it was less than she would be entitled to in court. Okay. And the judge turns to the mother and she says, you know, if you bring a motion, you know, you're likely going to get more. But in my experience, you know, payers are more likely to pay if they come to the agreement themselves. And I was just shocked that a judge would be saying this. But it goes to show you how powerful that is. So, you know, my client, if she had gone to a motion or to trial, you know, she would have received more. But the judge in this case was almost encouraging her to accept less than she would have been entitled to, in the hopes that it would, you know, produce better compliance results, right? And then another thing you have to think about in that situation is, you know, the motion or the trial would have been months down the road. So she may have received nothing until then. And it would, you know, it would have cost her thousands of dollars in legal fees for that. I talked earlier about the Family Responsibility Office and you know, ensuring compliance. There's limits to what they can do as well, right? So in industries where support payers are receiving cash, it's very difficult to collect. And usually, you know, those are the cases that end up with, you know, threatening jail time. But again, if the payer's in jail, you know, you're not getting any money as well. And other situations, like if the payer is self-employed, it's hard to enforce those situations. So something to keep in mind. You know, I have mixed feelings about this one. Customized solutions. So, you know, litigation, you know, this is a very simplified version, but one size fits most solutions. And in mediation, we can tailor the agreements based on the unique circumstances of the parties. I want to give an example. Okay, no, I'll do that a bit later. Okay, and reduce stress. So, you know, I think you're getting the sense of what court is like, and just mediation. There's just a less adversarial process. And a big thing is, like, you have control over the process, right? So it's voluntary. With court, you're giving that control to a judge. And, you know, in most cases, right, a lawyer, I'm able to tell my clients, you know, what they can expect from a judge and what the expected outcome might be. But you truly do not know, right? There's, especially at the lower level, when we're dealing with appeal levels, things are a lot more consistent. But at the lower level, it a lot of times is based on the judge you get. And there are definitely differences and between the judges, between the courts. So you can never know with absolute certainty what an outcome is going to be like in court. Okay, so before I move on to the case studies, I'll just check Are there any questions? Okay, no, we're good. So I'm gonna do just a few examples of how things were dealt with. And I think all of these examples are things that I've actually dealt with in mediation, and just I'll explain how they would have been dealt with in court, just so you can practically see the difference. So in this case, so I was mediating a case. It was just with the parties. They both already had lawyers. And the husband wanted to sell the matrimonial home, and the wife was living in the matrimonial home, and she wanted to wait 2 years to sell the home. And so in mediating this, I mean, it's important for them both to know, like, if we were in court, 100% the home would have been listed for sale now. So no, very rarely would a court not order the sale. So so the husband had this advantage in that he knew that, you know, if he goes to court, he can get the house sold, right? And so there's no basis in law why you'd wait 2 years. But what happened at mediation is I learned the reasons, you know, why they each had these different positions, right? So the reason the reason the wife didn't want to sell the home is because she was living in it, and she was slowly doing renovations to improve the appearance of the home. So there are a lot of projects that had been started that hadn't been finished, and she on her own was completing those renovations. You know, wasn't asking, and from her perspective, you know, she wasn't asking for contributions from the husband, and she sincerely believed that they would significantly increase the sale price of the home. The second issue is this happened recently, and, you know, in her opinion, it was not a great market to sell the property. From the husband's perspective, he agreed, right? He wanted the renovations done. He agreed it wasn't a great market, but he was strapped for cash, and he was renting a car by the week because he had no money to purchase a vehicle for himself. So he was raising a crazy amount of money, renting a car because he needed it for work. So once they learned each other's positions at the mediations, we were able to find a creative solution. So what we actually agreed on was that the wife was going to advance the husband some money so that he could actually purchase a car. And they agreed to only sell the house. They agreed to a year from now. So compromise on both sides. But, you know, I'd say this is a win-win because, you know, they were each able to have their needs met. And it's not that this information couldn't have been found out if we were in court, but, you know, we likely would, even me, I mean, I'm a mediator, but when I have my lawyer hat on, I probably wouldn't ask these questions if I was in court and we were dealing with these issues. So I really like that example. Another example, so two parents who are constantly exposing their children to adult conflict. So the court, you know, tries to deal with this, and you know, but it's challenging. So we'll usually have, you know, a court write things in the order, like, you know, neither parent will speak negatively about the other parent to the children, or they'll avoid adult conflict in front of the children, or they won't make disparaging remarks, you know, in front of the children. But it doesn't actually deal with the underlying issues. I mean, you can say, like, and those orders are kind of obvious, right? Like, yes, I mean, obviously no one intends to you know, to expose their children to adult conflict, but if you don't deal with the underlying issues, like, it's kind of setting people up for failure, and it's not giving them the tools that they need to actually implement, like, the plans that they want to. And, you know, obviously going on the assumption that no one wants to expose their kids to adult conflict. So what we can do in mediation is deal with those underlying issues. So looking at when is the conflict happening? And if it's happening at exchanges, well, you know, and it might be a situation where just seeing the other person makes your blood boil, and you cannot keep your composure, and there's conflict every time. And so what we can do is structure a parenting arrangement where you don't actually see the other parent, right? So it might mean, instead of, you know, picking up on a Friday at one parent's house and dropping off on a Sunday, it might mean picking up at school, so there's no interaction with the parents, and dropping off Monday morning at school. So now you've eliminated two potential you know, times when there may be conflict between the parents. The other the other thing that we can do is, putting kind of ground rules in for communication, right? So I recently did a really detailed parenting plan, and probably one of the most detailed ones I've ever done. And we went so far as to say how long each party would take to respond to emails. Or we actually wrote certain things that they could not write in text messages, right? So, I'm sure everyone's experienced that. You send someone an email, they haven't responded, and your mind starts to wonder. They're ignoring me, they're not prioritizing it. And that might be fine when there's, a solid base and some trust in the relationship, and you can kind of move forward. But when there's no trust, there's a lot of resentment, those things spiral, and it impacts, especially a co-parenting relationship. In this agreement, I also went specific, like one of the clauses, I'm just going to read it now that I include in the agreement. Like, they'll refrain from using exclamation marks, words in bold, or capital letters in their communication with each other. So, and that can be super triggering for people. So, and again, like I always tell my clients, the ability to enforce these agreements, you're not going to run to court to say that someone, used capital letters in their text message to me. But the fact that they're just having that conversation increases the likelihood that they'll try to apply these things. Okay, case study 3, parents who do shift work and require a flexible parenting schedule. I'm dealing with this situation now, and I'm dealing with a nurse who doesn't have the same schedule all the time. 1, it's changing. 2, they're really long shifts, so 12-hour shifts. And 3, it changes every 6 weeks. So it's not that courts can't deal with this, but unless there's a high level of cooperation between the parents, it really requires a very detailed approach. I mean, so court might write something, might order something like, every 6 weeks, the parents will, rejig the schedule to accommodate, the parent who has shift work. But what if they can't agree? Then we just have a court order saying every 6 weeks, they're going to get into an argument and they're not going to know where the children are going to be. So what we have time to do in mediation is actually put together a process, right? So in the file I'm working on now, every 6 weeks, my client, who's the nurse, gets her schedule, and she's actually they've agreed that they're going to have an equal parenting schedule. So we have a mechanism where she's going to input the schedule and how her schedule impacts the parenting, right? So she's going to write the parenting schedule down on a shared calendar. Then the dad will have, 24 or 48 hours to look at the schedule, share any concerns. And then we have something that will happen if they can't agree, right? And so in this case, we said that, on certain days or certain months, mom will have first choice. So if they both, want the child on the same day, and certain months dad will have, first choice, right? And so there's a dispute resolution mechanism built in to this plan, and not just, hoping that the parties will be able to agree on a new schedule every 6 weeks. Last example is a family business, right? So depending on the family business, there might be like a partnership agreement, and that might actually spell out what happens in the event of a separation. But I'd say most family businesses don't have a partnership agreement or a shareholder agreement. And so if you were in court, there's really limited things that a court can do. The court might order that the business be sold and those proceeds divided. If one person's buying out the other person, that might be an option. But in mediation, we have the time to actually, sit down and see if there's a more creative solution, right? So is there a way that they can continue to run the business? If it's a profitable business, it's in both parties' interest to continue working together on that business. Or there's situations sometimes where, the business, if you're creative enough, can actually be split, right? So I actually helped a couple who had a real estate business, and we were able to just, divide the properties, and they're just going to run their businesses separately. The same business, they're doing the same thing, but they divide the properties, and now they can, grow on their own. So, this is just another example of, I think, a situation where mediation yields better results. I'm just going to look to see any more questions. Okay, no questions. So I just want to talk a bit about myself and what sets me apart. So first, I'm a family law lawyer, and I only practice family law. I mentioned before, there are other areas of law will factor into family law, and I'll refer those areas out or have my colleagues assist. Real estate law, we obviously oftentimes need real estate lawyers and tax lawyers and financial planners. I'm an accredited mediator with the OAFM. So again, family mediation in Ontario is not regulated. So there are a lot of mediators that haven't been accredited. So this means that I've done a lot of courses. I've done courses on assessing power imbalance and dealing with domestic violence. And there's two schools of thought. A lot of people think that mediation is not appropriate when there's been domestic violence, and I would disagree. If the mediator has properly screened the parties and has training in dealing with domestic violence, and I think it's completely appropriate. I actually think it's safer. In court, there's no one managing the process, right? So in mediation, I control the process, and when there's been domestic violence, I make sure that the victim never accidentally bumps into their spouse, right? So that means that they come early to the session, and I put them in a room. Or they leave early, they're the first to leave, so they're able to hop on the bus, hop in the car, and they're not going to accidentally bump into their abuser. None of those safeguards are in place. I mean, with my clients, if I'm dealing with a domestic violence victim, I can put those safeguards in place, but there's nothing in court. So I can make sure that I meet the client early and walk with them to court, or I can request a virtual hearing, but the court's not doing that. So I have litigation and mediation experience. So my mediation clients really find my litigation experience valuable, because I'm able to tell them, what might happen if they go to court, right? And it's really important for them to know that when negotiating, because knowing kind of your alternative to a negotiated settlement is key to reach a settlement. And generally, I'm settlement and solution based in my approach, and anyone that knows me or has referred clients to me know that my goal is to resolve things as quickly as possible and in as cost effective as possible for my clients. And I'm also fluent in, so my background is Portuguese, and I've studied Spanish in school, so I'm fluent in both those languages and can assist parties in those languages. So I wanted to leave 15 minutes. I know I've been answering a lot of questions, but I wanted to leave the last 15 minutes for any questions or answers that have come up. I said I would check my email, but I did not check it once. So I know.
So Darlene, while you're checking your email, I just want to say thank you so much. Incredible presentation. And I'm going to turn the recording off now so that folks can bring personal questions and conversations if they need to. But this has been amazing.
Perfect. Thank you so much, Barbara.